Good morning, Your Honors. If it please the Court, my name is Alan Whitehead, and I represent the appellant who was the plaintiff below Jim Adam, doing business as Adam Construction. Surprisingly, we're here on primarily another attorney's fees case, like the last one we had. Just briefly, I'll talk about some of the facts in the case, and then talk about two primary issues here in the argument here this morning. Mr. Adam was the contractor in this case. This is a construction contract dispute between Adam as the contractor and Versailles Condominium as the customer of the contractor on a project that went on for some time. And there were some changes to the project. And then, of course, at the end of the project, there was a dispute over payment. Mr. Adam and Versailles entered into a contract. The contract says the successful party in the litigation, the prevailing party in the litigation, is entitled to recover their attorney's fees. Mr. Adam did the job. He was not fully paid. He was compelled, in his mind, to file a lawsuit.
There's no construction lien in this case, right?
There was no construction.
It's purely based on contract theories.
Pure contract. Well, there were three claims. There was a contract and account stated or amount due type claim, and a unjust enrichment claim. But Mr. Adam was not paid. He felt compelled to file a lawsuit. He went to court. He presented his case. He was awarded a sum that was due and owing to him, thereby prevailing, as the judge specifically states in his final judgment. He prevailed on his claim to the tune of approximately half of what he was asking for. But he prevailed, and there was what we believe was really a set-off of approximately $3,200 for some railings that the court determined should have been reinstalled by Adam.
Did the court find who was the ultimate prevailer?
The court said both parties prevailed.
Well, that's what I mean by the ultimate prevailer.
I don't think the court made that determination.
Does it have to?
And I think he does in a contract case, because as the cases that we cite to in our brief indicate that the general rule is that you have one prevailing party in a breach of contract case.
Should we go by the net value rule, that is, who got the most money after you set up the adjustments, et cetera? It
would be nice if that were still the status of the law, Your Honor. I don't think it is, though. I think it's who prevailed on the significant issues at trial. And we don't know who that is. I don't think, from looking at the final judgment. We believe it was Adam Construction because Adam Construction prevailed.
I guess I have a problem because there's no transcript of the trial, is there?
There are excerpts from the transcript, yes, Judge.
How can we make a determination on the significant issues under Moritz if we can't review the transcript itself to see what was actually thought about?
I think that you can make that determination because we cite to the pleadings in the case and the ruling by the court. And I think the issue is, and there's a distinction here, I think, between this issue and another issue that I think we do need the full transcript for and we don't have. And I'll concede that point on the issue of the rails. But in this case, it's...
Yeah, I don't think there's any question on the rails. You don't have a transcript.
Yes, sir, I concede that point. But on this issue of attorney's fees, we look at the pleadings and we see what each side sought. And I don't really think it's up to the appellate court in this case to make a determination as to who the prevailing party is.
Well, it's a discretionary call on the part of the trial court, right?
Yes, sir.
How can we tell if he's abused his discretion if we can't look at the transcript?
Because of his ruling, because of his final judgment, which does not say who the ultimate prevailing party is. And that's where the discretion is abused. I think if he went through and said, well, Adam prevailed and recovered more money than Versailles did on their counterclaim, but Versailles was the ultimate prevailing party because they established these points and these were the significant issues, then I think that Judge, you're correct, that we would need the full transcript to explore that. But because Judge Silvernail doesn't do that in this case, he does not provide for a prevailing party. He says both parties prevailed.
Well, suppose we reviewed the record and found out he was wrong. Now, you agree with me that Lasco from this court says you can have a case that's with equipoise. That is, there were several points, you prevailed on two, you prevailed on two, so each party bears their own attorney's fees and costs. But if the argument is, I'm the prevailing party, there has to be some way to tell if the judge was right or wrong. And the only way to do that is to look at the record, to see the complaint, answer, motions practice, testimony, and to see, okay, you were right, Judge. Isn't that the way it's done?
Well, sir, I think that what we have to do is look at the pleadings, what we have to do is look at the final judgment, and what we have to do is look at and determine whether the court abused its discretion by failing to find in a contract case that there was a prevailing party. And the relief, it's our position, the relief should be remand for a determination of who the ultimate prevailing party was in the case. Now, the argument as to whether or not the exception to the general rule applies is a different argument, separate and apart from that issue. But it's our position the exception doesn't apply because in the exception, as one of the judges refers to, I think in the Lesko decision, the parties fought to a draw. Nobody won anything. And in this case, it wasn't a draw. Parties actually prevailed in both the KCIN case and the Lesko case. And then there was a more recent decision from this case, Merchant, I can't recall the name of it, but a 2002 decision from this case. All three of those cases, the ultimate result was plaintiff, you get nothing, defendant, you get nothing. And in those cases, they talked about this exception applying in those cases because both parties fought to a draw and nobody prevailed.
I mean, what Judge Silvernail says is in paragraph 4, as to attorney's fees and costs, the court finds that both parties prevailed to some extent on their claims and both parties lost to some extent on their claims. And the court concludes that each party should bear its own part. I mean, isn't that sounds to me like he's saying this was a draw.
I don't.
I mean, he didn't use the word draw.
He
I mean, that's what it sounds like.
But he also says in there both parties prevailed, and both parties.
To some extent.
Yes, sir, to some extent. It's our belief that this case is more attuned to the Hutchinson decision, which we cite to in our reply brief. And in the Hutchinson decision, which was discussed by this court in Miller versus Jacobson Goodman, the Hutchinson case, although it involved Hutchinson versus Hutchinson, it was a contract for the payment of child support and alimony. The proponent in that case, seeking the attorney's fees, the wife, sought some $42,000, just like Mr. Adam in this case sought $15,000. The result was she got about half that because the husband was successful in arguing his set-off defenses and his and other laches type defenses. And the court said in that case, when the trial judge said no prevailing party, or the wife was not entitled to attorney's fees because she did not prevail, that the court needs to go back, case needs to be sent back for determination of who is the prevailing party, because in a contract case you have one party that prevails. So that's our position on the attorney fee argument, Your Honor. As it relates to the prejudgment interest, we believe that the exceptions argued by Versailles in their answer brief, the equitable exceptions do not apply, and that as a matter of law, this case was right for prejudgment interest. There was an amount determined to be due and a specific date as to when that amount was due. And on the other point, as I've indicated previously on the railing issue, I believe that we need a complete record, and it's not before the court. Let's
talk about the prejudgment interest. Where do you think prejudgment interest should apply, since the amount of the interest was not liquidated until the verdict?
I think that the cases indicate that the court will set the amount and apply it from the date. And in a contract case, you make a determination as to whether or not it is a contract that's paid in installments, or it's a contract that the lump sum is due and owing at the end of the job. and then you make that determination. In this case, the final bill was sent on February 29th of 2000, and that as of that date, the amount that the court determines is due and owing as of that date is the amount that prejudgment interest should be charged.
And your position is that the prejudgment interest should start at the date that the final bill is sent?
Yes, sir.
The bill at which you're,
The day-
by which you're arguing?
That's our argument.
And not the point at which the amount became liquidated, that is the date of the court's determination of the amounts of due and owing.
That's correct, Your Honor. That's, at that point in time, I think the post-judgment interest kicks in. It's prejudgment is what we're looking for.
Well, no, there's usually a time when the judge announces a conclusion, and a judgment may come at a few months later.
It's our belief in a construction contract case it's due from the date that the demand for payment is sent. Thank you, Your Honor. I'll reserve the remainder of my time.
You have 9 minutes, sir.
Thank you.
May it please the court. I'm Dennis Fairbanks, and I represent the appellee. I'd like to address the issues that opposing counsel has just brought before the court. First, we believe, as the court's pointed out, that the appellant failed to carry their burden by failing to furnish a complete record. And as that bears on this, the attorney's fees issue, the court found, as allowed in the Lasco Enterprises and the KCIN case, that there were both parties prevailing, and that there was therefore no reason to award attorney's fees to either side. This is a specific finding of the court. And that's authorized by those cases.
Well, I guess what your opponent is saying, Mr. Whitehead is saying, is that the Moritz case talks in terms of the significant issues, and the judgment doesn't really talk about the significant issues. It just says one side prevailed on some and lost on others, and the other side prevailed on some and lost on others. So do you think that the absence of the term significant issues bears on this?
Well, the case in Moritz says the significant issues, but I also think I can say that the court has the ability to determine, that trial court it should be the one that determines by looking at the facts and being the trier of fact. And so now we fall back to the issue of not having an adequate record. And so I don't think this court has before it what it needs to determine those significant issues. But I would point out one other thing, and it's stated in the...
Well, maybe you're misunderstanding my point. I don't think we have the authority to determine what are the significant issues. I think we can see what the trial court said and either agree with it or not, but we don't have that necessary authority. But the point I think that your opponent was making is that the judgment doesn't talk about significant issues using those terms. It just says each side prevailed on some of their claims and lost on others.
Well, I agree that that's authorized by the Lasco and the KCIN cases. That was part of our argument, is that this type of ruling is authorized. But I would point out that opposing counsel drafted the judgment that he complains about, which says on his claim. It is not.
Is that in the record?
Yes, it is. It's in the...
That he drafted it is in the record?
Well, the court says that in the transcript of the court ruling, that it says that he will draft the order, and he complains about that now. Now, this court, if there's any way to uphold the final judgment, they're going to do that because of presumption of correctness, even if they have to find an alternative theory that is not stated. And if they're going to say, if the final judgment says on his claim, the appellant has pled for breach of contract, goods sold, and unjust enrichment, this court could find that the claims was awarded on an unjust enrichment theory, which does not support an attorney's fee award. And furthermore, there's some justification for perhaps even conceiving that would be what the court's reasoning was, although it's not supported by the non-present record, and that is, if the court specifically found that the railings had to be included in the breach of contract claim, then by not doing that, that would be a breach that would prevent or would relieve the other party from liability to make payments. If that was the case, then it would be a misplaced idea to think that the breach of contract claim was what the appellant was being awarded their money on. They say on his claim there's a theory of unjust enrichment, which would support that ruling better than the breach of contract when the court specifically found that the railings were part of the contract and not performed by the appellant.
So you would argue to support his relief as long as the relief doesn't include attorney's fees?
Well, we're not opposed of the final judgment. We're basically in defense of it.
Right. Well, all of this guessing that you want us to do is devoid of a record. I mean, there's no way.
That's exactly what I'm
look
saying.
and say, well, this is a theory that was supported by the testimony that the judge opined might be a basis for entering this final judgment.
It's conceivable, but it's not supported by the record. But I believe the court will find any basis to support the final judgment if it exists as a possibility, unless the appellant presents a record that would support overruling it. As to the argument about the failure to award the prejudgment interest, this is our most difficult argument. The cases that we did cite are dissimilar facts. They only stand for the theory that if it was inequitable, the court is not mandated to do so, to award the prejudgment interest. I also agree that the appellant's argument cites that there are two things that are required: an out-of-pocket pecuniary loss and a fixed date of loss. And we don't know that because of the lack of a record, a fixed date that the court would determine. Because there's no record, again, even though it's de novo review, I would argue that the context cannot be seen and the facts cannot be seen, which would support that award of prejudgment interest. And so what we would ask the court to do would be to affirm the judgment.
Thank you. Thank you.
Just very briefly on the issue of whether our office prepared the draft final judgment or not, it's my belief that the court did ask our office to prepare a judgment. We obtained an excerpt of his ruling, which I believe is in the record, and followed that to the letter, and then, as is the custom in our county, passed the final judgment on to opposing counsel for comments, and I quite frankly can't remember what was or was not changed, if anything. Our concern on the fee issue is that the final judgment does not indicate who prevailed on the significant issues below, and does not follow the law as it relates to contract cases and finding that there be one prevailing party in a breach of contract case absent separate causes of action that do not arise out of the same transaction or occurrence. And that's our position. I'll stand on my other arguments on the other points.
Thank you, gentlemen. Thank you very much. And thank you for